As the war on drugs intensifies, there is concern that the battle is claiming an unintended victim, our constitutional rights. Emboldened by recent rulings, police across the USA are adopting aggressive tactics, including neighborhood sweeps, no-knock searches, reverse stings, and property seizures. I've lived through a lot of crime crises, but we've never gone out of control like this, says University of Michigan law professor Yael Kamisar, an expert on police searches. In Detroit, police raided a food market in a drug neighborhood, held the owner and seized his profits after dogs sniffed cocaine on three $1 bills in his cash register. Quoting Denver federal judge Richard Match, a Nixon appointee, "I wonder where the United States is headed. My concern is that the real victim of the war on drugs might be the constitutional rights of the American people." The Fourth Amendment, in its requirement that warrants particularly describe the place to be searched and the objects of the search, requires that the information that sustains a search be recent. If an informant tells a police officer, "You know, it seems to me that last winter I remember that Joe had some marijuana on the table in his living room," it is not permissible to rely on that information as the basis for a search today to find marijuana. Now consider the case reported in this article in USA Today from Hudson, New Hampshire. At 5 a.m., August 3rd, 1989, police came to the home of Bruce Lavoie, 34, a machinist with a wife and three children. Without announcing themselves and without evidence that Lavoie might be armed, police smashed the door with a battering ram. Police had a search warrant based in part on an informant's tip that was 20 months old. As he rose from his bed, apparently resisting the intruders, Mr. Lavoie was fatally shot as his son watched. A single marijuana cigarette was found. The casualties are not just abstractions. They have children, now orphans, who will never feel their father's hugs again, all innocent victims of the war on drugs. Incidentally, pickets later defending the police use of deadly force carried signs reading, "Druggies have no rights." The Fifth Amendment sets forth many rights and procedures, including the prohibition against depriving any persons of life, liberty, or property without due process of law. In the 1986 Anti-Drug Abuse Act, Congress created a scheme of mandatory sentences in drug cases, which I played a major part in drafting. 2 levels of mandatory sentences were set forth for transactions in quantities of drugs greater than certain threshold quantities, which was intended to give U.S. attorneys the direction to focus on the highest level traffickers and not waste time on the small fry. Unfortunately, the enacted thresholds, as watered down by the Senate and in conference, are no longer based on the realities of the drug marketplace. They were adopted without consideration of their effect in sentencing real defendants, without consideration of the effect on prison populations, and without study of their potential effectiveness in determining and deterring drug trafficking or drug use. Now, those mandatory penalties are used to coerce plea bargains. They give prosecutors the power to say, "Here's your choice. I can charge you with this offense, which carries a mandatory sentence. If you go to trial and you lose, you will get a mandatory 10 years without parole, up to life imprisonment for a first offense." Congress specifically prohibited parole in these kinds of cases. Alternatively, if you plead guilty to this lesser included offense, which only carries a maximum of 20 years, cooperate with us by becoming an informant for us. We'll recommend a lower sentence in the guidelines, such as 5 years or something like that. Very simply, faced with that kind of guilt of choice, a guilty plea is coerced, and the Fifth Amendment protection against denial of due process of law is lost. Let's think of another example of the erosion of the Fifth Amendment protection. Due process in criminal cases includes the presumption of innocence. However, in drug cases, Congress granted to the government the power to seize the power of suspects in advance of trial. Indeed, in advance of indictment. Another way in which due process is denied and the accused are unable to get a fair trial in some drug cases is by means of the mega trial under the continuing criminal enterprise action of the Controlled Substance Act. There are monstrous trials in which a score of defendants are tried together in dozens of counts of indictments alleging hundreds of different acts. Former Chief Justice Jack Weinstein of the Eastern District of New York, in his opinion in U.S. v. Gallo, spelled out how putting many defendants together in a mega trial undermines the presumption of innocence. National Law Journal, December 7, 1988, at 13. If the government accuses 20 Italian-American men with being members of an organized crime family and requires them to sit together at the same table in a courtroom for half a year and presents a continuous stream of testimony about conversations between and about Italian surnamed citizens, what jury isn't going to believe that they are all members of the mafia? Even when the evidence only applies to a few defendants, the innocent defendants are the victims of spillover prejudice.
That was too much.
Too fast?